sempre nella visione di Koskenniemi, a politics of international law. It's not pure. Non voglio perdere tempo, perché tanto così dopo abbiamo spazio per la discussione. Il professor Koskenniemi ha preparato delle slides, penso sarà facile seguirlo, lui parlerà in inglese, ma insomma per esperienza, avendolo ascoltato sia a Catanzaro, dove un amico, Massimo Latorre, ha avuto il merito di invitarlo, sia a Bologna, anche in occasione della pubblicazione del libro del Gentile Civilizer, che sarebbe poi il diritto internazionale, questo Gentile Civilizer. Si segue molto bene, e il tema di oggi è guerra e diritto, i paradossi di un progetto di civilizzazione. Ce ne sono molti. There are many paradoxes now in international law and in the politics, international politics. So, grazie. So, thank you so much. È la sua prima volta a Napoli. Yes.
So, thank you very much for that introduction. Thank you very much for the introduction. Yes, I'm really embarrassed to be here for the first time, and even now only for 2 days. It's ridiculous. And I'm going to New York for my annual teaching next week. And usually, or often, my daughter accompanies me. And I asked her whether she'd like to come with me to New York, as she's done many times. She looked at me sadly and said, "Dad, I think the carbon footprint of our family is big enough without me." And so, yes, of course, going places is a destructive thing to do. And so I'm doubly embarrassed of having flown here and flying away from here tomorrow, destroying the atmosphere while doing this. Okay. But to begin with this presentation, maybe I should say that I'm going tomorrow to The Hague, where I participate in a committee that has been set up by the Dutch Foreign Ministry to discuss the rules of use of force today. You see, in the Netherlands, a little political crisis emerged last year, when in April 2018, the Americans, the French, the British hit with missiles Syria because of course, what had happened there and the suspected uses of chemical weapons and crimes against humanity. And the Dutch government said it supported that action. Now, the action had not been authorized by the UN Security Council, and according to the really easy rules of international law concerning the use of force, one is entitled to use force only for 2 reasons. One is for self-defense, but obviously the Americans were defending themselves when they were attacking Syria, or under Security Council authorization, under Articles 39 and 41 of the UN Charter. But there was no authorization. And of course, they wouldn't have received any authorization because the Russians, the Chinese would have vetoed. So they just struck at it. So it was illegal, technically speaking. But the Dutch government said, go ahead, that's a great, and because the Dutch are very legalistic, which is a good thing sometimes, it's a problem at other times, but they are very legalistic. So the Dutch parliament reacted, and as a result of that reaction, the Dutch Foreign Ministry set up this little committee of international lawyers from Holland and from elsewhere. I was invited to be part of that. So it's an interesting moment. Many people, not only in Holland, but certainly in the UK, in France, in the United States, think that the present law concerning war is obsolete and should be changed. And so whatever I'm going to say today may be less a presentation of present law than it now is. Anyway, I'm not that interested in law in itself. I'm interested in law as an argumentative structure and as a political intervention in the world. What I'm going to do today is to try to give us a sense of what this talk about humanitarian intervention and responsibility to protect and self-defense and use of force and Security Council, how we should think about that. How useful or clever is the intervention of law? And I can only do it by beginning with a little historical sketch. So, let me put it in this way. Once upon a time, there was supposedly, at least this is the myth nowadays, supposedly there was no law on the use of force. Instead, the rules in Europe under which diplomats and men, of course they were all men of state, were thinking about about war, was under balance of power. So this is the 19th century, the concept of Europe system. Whether it was like this, that might be dubious, but in the collective imagination of the lawyers, when we think about why we have these rules that we have, this is where we start. And according to this mythology, the opposite of law is politics. And what does that opposition mean? Well, in law, you're bound by rules. And if there are no rules, then you're in politics, because you can do whatever you want. The balance of power, according to this thinking, the balance of power is the epitome of politics. Why? Well, because it's based on everybody constantly watching everybody else and changing their position and their activity by reference to the changes in what other people do. So balance of power is premised on there not being a rule. You get that? Because you have to be free to react every moment. So that's the balance based on political discretion and free maneuvering. Now, according again to this collective myth, the balance of power was destroyed during the run-up to the First World War, the famous or infamous July crisis, the attack in Sarajevo, the reaction by the Serbian government, the reaction by the Russians, the reaction by the French, etc., etc. The Germans, the Austrians. There are very exciting diplomatic accounts of how diplomats during the period from the assassination in Sarajevo in June to the beginning of the guns of August, in August, how the diplomats during July crisscrossed Europe in trains and in carriages and cars and by horse in order to try to prevent what was happening. But it all went down like dominoes. There was nothing you could do. That's the story. Again, I'm not interested in whether that's historically true, but that's how 20th century lawyers, diplomats, historians present the emergence of what then became collective security under the League of Nations. So, okay, First World War and then collective security in the League Covenant. So the idea was that we should now no longer let anybody be free to act. We should have rules on the use of force, or rules against war, as they then said. And we should have an institution and institutional decisions as to who has breached those rules and what to do if there's a breach. That's called collective security. Collective security is the epitome of law. And in the young profession of international law, that's really responsible for the system of collective security, negotiating it in the League and etc. So their sense was that we move from a world of politics to a world of law. Now this is what the League Covenant says. This is the rule. Should any member of the League resort to war in disregard of its covenants, it shall ipso facto be deemed to have committed an act of war, and everybody will react immediately. So no discretion, no freedom. It's like an ultimatum. You go to war, we will immediately take action against you. It's a Three Musketeers pact, one could say. Athos, Porthos, Aramis, D'Artagnan. One for all for one, right? You hit one, we all immediately undertake the severance of trade and financial relations with you. So as a legal rule, it's as good as it can be. It defines what the breach is, act of war, and it provides the consequences. And it's crazy, absolutely crazy. So for the first time this rule was applicable was in the Chaco War in Latin America. So between, I think, Uruguay and Paraguay. Anyway, countries of whom nobody had heard. And what? Should we now go to war against Uruguay? I mean, I can think of people in Helsinki thinking, well, what? Should we now sever our relations? Anyway, so nobody disrupted their economic or financial ties with Paraguay and Uruguay. And people sent, diplomats there and tried to negotiate while the little war was going on. But they didn't think of that as really a dramatic problem. They still thought that Article 10 of the Covenant, the law of war is ad bellum, is what we want to have. Then the Manchurian War. So all of a sudden, an explosion in the Trans-Manchurian Railway that had been leased to Japan in the 1920s, and the Japanese accused the Chinese nationalists. They had done it. And so they bombed parts of China, the rape of Nanjing, and Japan and China were both members of the League. So Japan had entered into war against China. What did the League members do? So they wanted to know whether it was a real war, and they set up a committee, where at the time the so-called Litton Committee. Because the Japanese ambassador said, and you recall the formulation, if a League member is resorted to war, the Japanese said, well, it's no war, it's just a police operation. Never mind hundreds of thousands of Chinese in Nanjing and elsewhere are killed, but it's just a police operation. This is what law does to you. Law gives you words, war, which lawyers then use in order to help their clients. Oh, it's not war, it's just something else, it's police operation. And so the Litton Committee sat for 1 year in order to find out whether the massive military operations and the establishment of the puppet regime of Manchu Kuo really was war or not. When, after that 1 year, the committee really found out, well, actually, Japan had engaged in war, it was too late to do anything. Well, then I need to talk much about Italy and Abyssinia. Of course, Mussolini said that if the League members will limit their trade and especially their selling of oil to Italy, Mussolini will immediately declare war against those of League members. Now this is now 1935, 1936. What is the most important consideration in the minds of European and I suppose American diplomats regarding the Italo-Abyssinian War? It's this: how can we act in such a way as to prevent the axis between Italy and Germany from taking place? Mussolini said, of course, if you take action against me, I have a friend over here in Germany and we'll just align with that person. And of course you didn't want to have that. So of course no significant action was taken by any league member. And I have to say, as a form of, so in my previous life I used to be a diplomat, so I was the legal counsel to Finland. I've sat in the Security Council when Finland was there. So I have to say, I understood them. So here, the cliche that law is not a suicide pact was really pertinent. We didn't engage with so I'm speaking as a Finnish former diplomat, so we didn't engage in the League of Nations in order to go to war against Italy. That was not the point. And if we did, then that was a bad decision. Okay. The remilitarization of the Rhineland, I didn't need to go there. So here is the problem with law in war. So rules are really good. They are really good because they deter. Only if you have a clear-cut rule against somebody using force, that somebody can then think, well, I shouldn't use force because otherwise Athos, Porthos, Aramis, and even D'Artagnan will hit at me. So I had better not do it. If you don't have a rule like that, then everybody can, think, well, maybe I can get away with it, and maybe, maybe it's not war, but police operation. Lawyers are resourceful people. So rules are good because they don't allow political manipulation. Here is the line, But is it true? So war, police operation, well, you can say use of force, and that's what the UN, of course, says. Rules are efficient and fast. You just, empirically, you're there with your binoculars, and you see tanks go over the boundary. Ha! That's it. Nothing else. So it's an objective determination. It's like a crime. The police conducts an investigation. It's easy to operate. Use of force or war or not war. The rules treat everyone in the same way. They put people in an equal position. So we don't just think, well, if it's war by America, it's one thing, and if it's war by Finland, it's another thing. Well, it's the same rules hit everybody. That's the theory. They do not rely on social cohesion. This is a more complex but a really important factor about rules. So why do we need rules? So why don't we just act in a just fashion? Well, it's a good idea to say the society should be ruled by justice, but there's a problem with that. And what is that? Well, we disagree with what just behavior is, and it's only if we have a spontaneous solidarity, social cohesion, solidarity. I should actually have written there, solidarity. So then we can live without rules. Rules are melancholy second best. We don't know what justice is. We hate each other's guts. We have no solidarity, but we have rules. Okay. So that's why we have rules. That's the point of rules and law. But rules are bad. Why are they bad? Because they generalize every conflict. So the Chaco War, it wasn't so in principle, a strict application of Article 10 would have made the Chaco War the World War, because everybody would have then been against them. So you don't want to do that. There are many instances like that. Little wars in Africa, for instance. Little for us, we are here, but it's hundreds of thousands of people killed. So you don't want to universalize every conflict, which is what rules do. Everybody becomes the adversary of the one who breached the rule. They do not take into account particular circumstances. The circumstance, and this is now a personal war story. So Finland was a member of the UN Security Council in 1990 when Iraq invaded Kuwait. You may remember if you were born by that time. So Iraq invaded Kuwait. And the Security Council took action. You remember, Operation Desert Storm. So everybody thought, oh, well, finally the UN acts as it was supposed to. Security Council makes a decision. Now, and everybody needs to sever immediately their economic ties with Iraq. Now, as a Finnish diplomat, it's really easy to vote in favor. How much trade does Finland have with Iraq? Well, you know, a couple of tens of thousands of euros, I suppose, maybe even 100,000, etc. Now, if you are a diplomat from Jordan, cutting your economic ties with Iraq, what? Getting 90% of your oil from Iraq, over 50% of your foreign trade with Iraq. So rules treat Finland and Jordan in the same way. It wasn't highly publicized that in the secret meetings of the Security Council, everybody said to the Jordanese, you just keep on doing what you do. Of course we understand you. And we would do the same if we were in your position. So you need to take into account particular circumstances. You need to open up discretion. Rules are therefore dangerous to apply. They hit people differently because they hit people differently because they hit people in the same way. They hit them differently because people or countries are in a different position. With regard to Italy, for instance, in the Italo-Abyssinian War, it's one thing for South Africa to take action and another for Greece to take action against Italy, for example. So it's dangerous. Put countries in a de facto different position. And they, in the end, they rely on social cohesion. Why? Well, because this is what would have been needed in terms of Manchuria. But there was no cohesion, so nobody wanted to apply the Article 10 against Japan because, well, you know, Chinese. I mean, Europeans are racists. I mean, I don't have to tell this to Italians nor Finns. We know we are racists. And my Chinese doctoral student came to my son the other day and complained to my son that why are the Finns so racist against a Chinese person? My son was really shocked. He didn't say, well, are we racists? But of course we are. And if you think about the war between China and Japan and you're a European, you're much less worried than if it's a war between France and Germany. So no action was taken. So that's the problem. Rules are both good and bad. That is the experience of the League of Nations. So Article 10 of the Covenant was to bring law to bear upon war. Now we have easy to apply rules and everybody will be peaceful. It didn't turn out that way. And everybody needs to understand this. This is because rules are not only good, they are also bad. And therefore the UN Charter is different. The UN Charter no longer talks about war because of the Japanese police operation. Instead, it now talks about the use of force. So here is Article 2.4. Members shall refrain in their international relations from the threat or use of force. So now you don't need to, it's more open-ended. What is use of force? Lawyers debate on that. And then no automatic reaction. The Security Council shall determine if there is a threat to the peace, breach of the peace, or an act of aggression, and make recommendations to states. So now and many people say, it's balance of power once again. It's just balance of power between the members of the Security Council. They decide what action will be taken. And most of the time, as you know, most of the time of the post-war era, no action was taken. The Americans were happy to wage their war in Vietnam and kill hundreds of thousands of Vietnamese, Cambodians, Laotians, and people just were looking elsewhere. The wars in Africa, the Security Council never took any action. Then this event in which I was a little tiny participant, the Iraq War, when all of a sudden people were saying, well, here there was an attack by a UN member state, Iraq, on another UN member state, Kuwait, occupation of Kuwait, annexation of Kuwait. That can't happen. I remember I was this was in August 1990. As I said, I was posted in the Finnish permanent mission in New York at the time, and I was the legal counsel of our Security Council delegation, but I was on holiday in Finland. I mean, all of these things always happen when people are on holiday. There's a reason to. So they called me up from a country house to Martti to go to New York, and because there's this emergency situation. I was sitting on the plane thinking, oh, isn't this great? This is one of the biggest crises in the post-war era, and I am needed to solve it. But of course, the point was that they felt that it was the first time that these rules were supposed to be applied. There are many other rules here, Articles 30, Articles 40, 41, 42, that deal with economic sanctions, military sanctions. Article 48, which says if the UN takes military action, then there shall be a military staff committee set up to direct these actions. None of this had ever been tried because of the Cold War. And now there was the rule of law. This is now 1990. Rule of law, liberalism, neoliberalism, all that. I'm sitting there on the plane thinking, okay, so law, rules now. And in the first meetings in August, September of the Security Council, it was really surprising to see all the permanent representatives of countries have the little blue book, the UN Charter. And they were really asking questions. Well, you know, can we take military action before we have seen that the economic sanctions have proven themselves as useless? Or have we first always have to try to take the economic measures? What about the military staff committee? How do we elect that committee, etc.? And I remember the crazy legalist that I was at the time. I remember cabling back home to Helsinki asking for instructions, because that's what you do when you're sitting there in a committee. So you ask for instructions. But always when you ask for instructions, you always propose what the instruction should be. The expectation is that you are there on spot, so you know best. So tell us what you suggest. And so I suggested that no military action should be taken before the military staff committee has been set up. Because that was the idea of the drafters. If the UN takes military action, the military staff committee should set up. Didn't take long for a cable to come back to me and said, Martti, it can't be like that. This is an American operation. So it is the UN won't take action. Finland won't take action. If you don't understand that, you are not, why are you sitting there in New York in the first place? So, and of course, when Secretary Baker, there are a couple of meetings that have been burnt in my mind from that autumn 1990. When Secretary Baker, James Baker, came to the Finnish mission and laid out what then became Resolution 678, which was the all necessary measures. Take all necessary measures. So we saw that resolution, and there were the resolution was undertaken, I think, on the 29th of November. The first drafts we saw from the Americans were from September. So there was a 2-month period of negotiation. The only thing that changed in the original American resolution was the ultimatum date. In Secretary Baker's resolution, it was 1st of January. In the final resolution, it was 15th of January. And it was 15th of January because the troop concentrations in Saudi Arabia took a little bit longer than the Americans had foreseen. So all of this negotiation, the legal council there, the Finnish council, the Canadian council, etc., no influence whatsoever. Anyway, that's how this thing operates. And is that a good thing or is it a bad thing? Well, we can think about that. Now, but so this is all background. I realize I've already spent a lot of time, and old men like to tell war stories, so I apologize for these war stories. But that's, so a different kind of a problem emerged. So the first picture is from bombing of Belgrade in 1999. This is the television tower of Belgrade. The NATO was thinking that Serbian troops will enter Kosovo and will carry out the kinds of crimes and actions they had carried out in Bosnia, etc. And the other one is an image from George W. Bush declaring mission accomplished in 2003 after the American attack on Iraq. What unites these two things is that both are formally illegal. Because there was no Security Council authorization. Some of the NATO lawyers, poor lawyers, because you have to argue, even in bad cases you have to argue. The NATO lawyers were saying, well, you know, the NATO was kind of defending itself in Kosovo because, you know, the Serbians threatened the balance of power in the Balkan area, etc. I mean, you have to argue. I was arguing in the International Court of Justice in the Kosovo case 2010 that, the case went to the ICJ, as you may know. There's a famous advisory opinion by the International Court of Justice on Kosovo, and many legal counsel of EU countries were invited to give their opinions. And I'm kind of a notorious person, so I was asked to give opinion to the court. But I of course had to, so I was a counsel for my country, and my country supported this illegal operation. And so what I said, and what most of my colleagues said, was this, that yeah, it was kind of illegal, but it was legitimate. And we went then and looked in the mirror, wondering, what on earth did we mean when we said that? So it was kind of easy to say that Kosovo was illegal because there was not even a serious attempt to get a Security Council resolution. And of course the Russians would have vetoed it immediately. And the argument of self-defense was just pathetic. So this was, and people started to talk about humanitarian. I come to responsibility to protect in a moment. But what we said was illegal but legitimate. By this we said, well, we are good lawyers, we know it's illegal, but we are also people with our hearts in the right place. So it was legitimate. So it was that having your cake and eat it too thing which we were having. Now, the 2003 thing was very different. Of course, the Americans said, if they bothered to say anything, because law is not such an important, international law is not such an important figure in their speech anyway, they would say, well, things such as, well, they were acting in accordance with the purposes and principles of the Charter. Because Saddam, weapons of mass destruction, all of that, it's against the purposes and principles of the Charter. They were saying that Saddam was in breach of the ceasefire resolution 687 that followed the original Iraq war from 1990-91. And that the breach of that ceasefire triggered the original authorization that I had the misfortune of being witnessing. Well, anyway, most people said not only was it illegal, but illegitimate. So I found myself saying that, and many other people said that as well. So this is a problem. How do you deal? So diplomacy is a field of complexity, and law is part of diplomacy. To say something is illegal but legitimate is an immensely complex philosophical thing to say. So jurisprudential nerds have for a long time tried to, understand what it is to say that. But of course, Western lawyers, good-thinking Western lawyers, could not live with such ambiguity and ambivalence and paradox. illegal but legitimate. And so from 1999, a process started in the UN and in many Western capitals, also in Rome, in which people tried to look to it whether it's possible to amend the UN Charter, whether it's possible to have a new rule that would make lawful that which used to be illegal but legitimate. The report of the International Commission for Intervention from 2001 gave us the vocabulary of responsibility to protect. In the famous ISIS report from 2001, a group of highly respected politicians and diplomats proposed that if a state is unable or unwilling to protect its population, the international community, then will take action and intervene. People have, of course, wanted to avoid the word humanitarian intervention. It's every now and then it slips from the tongue. That has a bad reputation because it's too much like the white men intervening in the colonies. But so responsibility to protect. There was a little, the best moment for this idea that there should be allowed an intervention, a military intervention outside the two rules, self-defense and Security Council authorization. There should be intervention if there's a humanitarian crisis emerging in 2005. This is the UN 70th anniversary, a big declaration, World Summit, in which 2 paragraphs, I know this very clearly because, again, it's always it's the same crowd of people who are invited to draft those paragraphs, in which the heads of state declare that if a state is unable or unwilling, then all necessary means should be considered. It doesn't say that you shall be hit by military force, but it says, you might just be able to hit by military force. So that was a big moment, and lots of champagne by Amnesty International activists and right-thinking Western humanitarians, and so on. The first and only time that this new rule, this obscure rule, has been applied was in the Libyan situation, 2011. You may recall there was an uprising against Gaddafi, especially in Benghazi, in the city of Benghazi. Gaddafi threatened that he will just annihilate everybody in Benghazi if they don't stop. And people were afraid that, well, that's what would happen. And the Security Council gave an authorization to NATO's, it didn't mention NATO in the first resolution, but for countries able and willing to take action to prevent a massacre in Benghazi. And of course, when those authorizations are given, they are never given to Finland. But so it's always the same guys who have the ability and the will. So, those guys, France, Britain, I don't know about Italy. Italy has a stake in Libya, of course. Maybe the Italians also. So they decided that it's not just that you strike at the road leading from Tripoli to Benghazi, but you actually have to carry out a regime change, because the regime is the problem. And if you are a social scientist and an international relations problem, you can say such a thing. And there is some truth to it. The regime is the problem. But when the Western allies then ousted Gaddafi, the Russians and the Chinese came out immediately saying, "Ha! We knew you would do this. We knew that you would misuse this authorization." And both of them said, have said many times, never again. So much for responsibility to protect. Until now, the strikes last year in Syria, and of course many people have been very worried. How can we just sit here in our capitals while 560,000 people, I think, is the latest body count, something like that. Millions of people internally displaced and as refugees. So people keep on talking. It's not going to go away, evil, I mean. And now this is my, what I want to, I think, finish with, although I do have some slides, but I know I've been talking too long. So there is an international effort underway in many, many capitals of trying to rethink the rules on the use of force. And I have participated in that debate for now, ever since Kosovo, really. I am a skeptic. And what I'm going to put forward to you is a skeptic's position. It builds on everything you've heard so far. So there's an effort to have a rule on, let's call it humanitarian intervention, even if that's politically slightly incorrect. And how can we think about that? Well, what would be a good rule that would cover the authorization, the right to undertake humanitarian intervention? This would be a good rule. I'll give it to you. Everybody should take military action if there is a big humanitarian crisis. Now, why is it a good rule? It's a good rule because it says precisely what we want to do. We want to allow people to take action if there's a humanitarian crisis. But we don't want that rule. Why? Well, because it's too open-ended. Because anybody can say whatever is a humanitarian crisis. I mean, the Catholic Church thinks that abortion is a humanitarian crisis. The Me Too people think another thing is a humanitarian crisis. I mean, everybody thinks their problem is a humanitarian crisis. That's not a problem in itself, but the problem is that if you then authorize people to take military action, as I said, you never talk about Finland and Sweden. You always talk about whether the Americans can or should not. And you don't want to let the Americans, to decide whenever it is to act. The rule is too broad. It provides too much discretion. So you want to have a really, really clear-cut rule. A rule that could be objectively verified. Let me give you one rule that would be such. It could be, if 500 are killed, so you are entitled to intervene if 500 are killed. That's an excellent rule because it gives no discretion to anybody. And now I think it's really important that we understand why it is that we don't want that rule, the 500 rule. I mean, most people intuitively feel that it's a crazy rule because it's kind of arbitrarily. Why not 600? Why not 50? Etc. But let me press you on this a little bit. What does a legal rule do? A legal rule permits everything that it doesn't prohibit. And the more bright line the rule, the clearer the rule, the clearer the permission. Now imagine the UN General Assembly enacts a rule that there shall be heavenly intervention if 500 are killed. Imagine this situation. There's a tyrant somewhere, and the tyrant wants to build a new summer resort in a place where there's an indigenous population living. And so the tyrant says to her military leader, well, just wipe away those people. 1,500, who cares? Nobody, so they are primitive, of other race. Now, the legal advisor then comes to the tyrant and says, well, Madam Tyrant, unfortunately, the UN General Assembly has just enacted a rule according to which there will be heavenly intervention if 500 are killed. So I'm afraid, Madam, you can't just slaughter them. And then the tyrant will do what every politician does with a lawyer at that moment. she will turn to the lawyer and say, but you're the lawyer, so tell me how I can go to where I want to go without breaching the law. That's what lawyers are called upon to do. And so the lawyer has an easy task here. The lawyer will say, well, Madam Tyrant, what you could do is that you order your military to take one blue-eyed girl from every indigenous family and nail them on the cross, one after the other, and tell the people that I will stop this crucifixion as soon as you leave. And I bet you that they will leave before you get to 500. And if they haven't, you just stop when you get to the 499th crucified child. So the law here would be this imaginary, impossible, but still absolutely real law. The law would be responsible for the crucifixion of 499 babies, blue-eyed girls from these indigenous families. And imagine the situation. So you have the intervention force, blue helmets, the latest military gear. They are just behind the border, and they start. How many are being killed? We wait until 5. Well, of course, no. You want the intervention to take place before the crucifixion starts. But the rule doesn't allow that. So you're back in. Intervention must be possible whenever it's a really bad humanitarian situation and fundamental values are at stake. But hold on, that was precisely where you wanted to leave from, because that just gives the Americans the ability to hit whomever they want, wherever they want, because they can always say. So it opens the war for imperial wars and cannot be controlled. So in a sense, this is one place where I could leave you. It's a really dark place. I mean, if you're a lawyer. Oh, not so dark, because, lawyers provide these arguments. And we are very skillful in justifying things that you find abhorrent. So, but maybe I'll just give you this. So this is a slightly more positive note. So, law and war link to each other differently from how law and society link to each other domestically. In domestic societies, rules operate in predictable ways. So, for instance, the problem of over and under inclusiveness that emerges in the international field doesn't operate in the domestic field. If we think of the 500 humanitarian rule, it's it's under-inclusive because it doesn't include the situation when the crucifixion starts. And you want to include that. A rule is always a generalization from past behavior. We regulate in order to prevent things which we knew that took place in the past, but the future, whatever else we can say about it, is different from the past. And so when we enact rules by reference to past, they miss-target the future. They are under-inclusive. Well, they don't allow you to intervene when 5 have been killed. But they are also over-inclusive. And the 500 rule is over-inclusive because it does allow the Catholic Church to intervene for the hundreds of thousands of abortions every year. So you have to be able to make a distinction between the blue-eyed girls being crucified and abortion. But you can't do that numerically. So the rule has to be open-ended. In domestic societies, rules operate like this. Think of this, the speed limit. So what do we want to have by speed limits? So we want the traffic to be smooth and safe. So why don't we enact a rule according to which the drivers should act in a way that's safe and smooth? That would be a good rule, wouldn't it? Because it says precisely what we want. Well, because we can't trust drivers. So imagine a situation where a car comes in in an empty desert, and there's a crossing in the desert, and the driver sees miles in every direction. There's no car coming, but there's a red light. And so you just drive. But the police sees you, and they fine you. And you can't say, well, but there was nobody there, and it's a silly thing. The rule is a rule is a rule. The police would make a mistake if they didn't fine you. And why is so? And imagine that there was somebody in the back seat who needed to get to the cinema. And he didn't see the film because he needed to wait. So there was a loss to that person. But we can so we can accept that loss. Why? Well, because we know that when the rule is being applied in the thousands upon thousands upon thousands of situations, it brings about broadly the right result. The rule and the marginal cases, the cases when you go to the hospital, the cases where you could see miles and miles, the cases where it's an inconvenience, they are not as weighty, as important as the social practice of everybody stopping at red light, even though it's really pointless. But now think of war and the international field. The rule on humanitarian intervention isn't expected to be applied thousands upon thousands of cases so that you can accept a little over-inclusiveness and under-inclusiveness in the margin. No, even one mistaken application is more important than the rule. So you want to breach the rule. Even if it's a 500 rule, you want to go when the crucifixion starts. And you go there and you wait, and do people protest? So in the international world, the faith in empty rules cannot be presumed in the way that it can and should in domestic societies, which are sociologically thick. But when you legislate for single important events, then that legislation really is hard or maybe impossible. Thanks.
Well, so much. Thank you so much for your very interesting presentation. And we can start with the questions. Anna Cavaliere, the first question.
Thank you. My question is that I think that nowadays it's not possible to imagine a domestic analogy, so in the international law, for the reason you have explained, but also because subjects are not equal, no, in the world. So the project of a domestic analogy that was at the center of study of many philosophers like Habermas, it's not realistic or not? Thank you.
Yes, well, I think that's true. And international relations scholars, E.H. Carr, Hans Morgenthau, those people have, and others, have often pointed to the lack of imagination of lawyers who, or philosophers or thinkers who use the domestic analogy. As a social context, the international is in many ways very different from the domestic. Rules operate differently in those contexts. On the other hand, I don't think it's an utterly complete separation of the two spheres. I think of it more as a sliding scale, so that there are international questions on which it's possible and has been possible to legislate and to decide. The cliche is postal and telecommunications relations and planes flying and criminal cooperation between administrations and immunity of diplomats. And so there are many, many fields of law that are not very, fields of the international, in which there are routine types of behavior that can be regulated by rule reasonably well. But war cannot. Now, the domestic analogy, however, the point is important, but it's a limited point, to the extent that maybe international law never was intended to be what you would call a regulatory tool. Maybe international law is an ideology. Maybe, and this is what I've been, so in this book that was mentioned, The Gentle Civilizer of Nations, I describe international law as a project. It's a project that was born in the late 19th century, in particular to attain two things: to civilize the colonies and to liberalize Europe. And the first international lawyers, sociologically speaking, biographically speaking, the ones who spent most of their professional lives in the League of Nations, in the various committees, so they were cosmopolitan liberals. And they had very definite political objectives, both domestically. They were in favor of abolition. They were in favor of abolition of death penalty. Some of them were feminists. This is true. Actually, there will be a book being published by one of my students on James Brown Scott, an important American internationalist in the interwar era, which was a feminist. So, and they had all this agenda for freedom of enterprise, free trade, etc. And if you think of it in those terms, then the domestic analogy does have more application. So these are people who bring their agendas from the domestic to the international. They don't see such a difference there. So maybe just to sum up, so the critique of the domestic analogy is powerful if it's applied to law as a regulatory tool, as an instrument of legislation. But it's not that important if you think of international law as an ideology or as a project. And I think it's often useful to think of it in those latter terms.
Maybe the problem is how much ideological the international law is, because there are limits. Law expresses ideologies, but law is ideology, neoliberal ideology, liberal ideology, democratic ideology, at all. I think it's a problem. There is a relation, a connection between ideology and law, but if law, international law, is ideology only, is a problem.
Yeah, but I'm not saying that it's ideology. Yes, so maybe there's not a, so the way I usually put this is by showing my students the image of the Wittgensteinian duck rabbit.
Yes, yes.
So, so we can think of international law in many ways. It's not just one thing out there that has a center of ontological gravity, to put it in ways that philosophers might appreciate. So it's a perceptive thing. It is what we make it. And it can be imagined as a regulatory tool that's neutral in regard to what it regulates. But it can also be described as an ideology and a project and a politics. So I've always been faced with the question from audiences, but Martti, it's just politics. As if that were a bad thing, by the way. So this is the duck rabbit. So if you think of, so it's possible to think of every rule in terms of the politics of that rule. What interests does it advance? Who made it be? Who applies it? How is it being applied? How is the intervention of the rule visible in the distributive consequences in society? And then it's duck. But then you can also describe it as a rabbit by just looking at this as a rule that has a meaning to which you apply interpretative techniques and which has a role in legal institutions of a particular kind. How would I put this? So I don't think we should be thinking in terms of black and white as separate from each other. Black and white, so the world is gray. That is to say, it's a mixture of black and white. But you can't get to the gray without having a concept of the black and the white. So you have to have those as concepts. But the world is never just one or the other. It's always a gray zone. I'm sorry about these metaphors. I find that I'm sliding into them when hard questions are being posed, and people, of course, think that I'm kind of running out from the kitchen door.
Okay. Giovanni Bisogni.
Thank you, Professor, for your humor presentation. Your conclusion reminds me the position of Herbert Hart on international law. Herbert Hart said that international domain and domestic domain are completely different each other. So what is valid in international, domestic domain is not valid in international domain because the reality is completely different. Above all, regarding the use of force. Herbert Hart said that regulating the use of force in national domains are necessary tools, not conceptual, but empirically necessary. It's not the same in international domain. So, if I'm correct, your conclusion is that it would be better to come back to balance of power regarding law and war, or at least to have just a principle, not a rule. A principle like every state must refrain from the use of force. That's enough. The rule, the law, could be good for trade, for diplomacy, but not for war. Is it your opinion?
Yes, it's at least my opinion is something very close to what you say. Let me put it in this way. So as I said, I'm tomorrow going to fly to The Hague, in which, within a group of international lawyers, once again we discuss what can be done with this set of rules. How should we understand that? Was it the wrong thing for the Dutch government in April of last year to say that they support the illegal use of force by US, UK, and France? And I already know that the discussion will not end up in anything very tangible, but it's a discussion that needs to be waged every now and then, so that we remind ourselves of the great difficulties of regulating war through rules. It's not so to remind us that we don't refrain from regulating war with really powerful rules because we are stupid or evil. We refrain from that because it's a really tough nut to crack. And every regulatory effort has a really obvious dark side. So you cannot not look at that dark side as well, to rephrase Monty Python. But I am, how would I say? So I have a long experience both in diplomacy and in law, and I am skeptical about large legislative projects in the world. I think so much of what happens in the international world is dependent on the tremendous injustice that rules the international as a social sphere. And that to tinker with ideas about law and legality on the surface is bound to be ridiculous or pathetic or somehow beside the point, because everything is so as I said, so in a sense, I can't get over the fact that my daughter refused to fly with me to New York because she thinks that I am destroying the atmosphere. So, you know, why am I talking with colleagues flying business class to these places? Not always business class, but anyway, flying. And so there is this sense that we are dealing with scheinprobleme, so with problems that aren't real problems because of the way the world has situated us in these privileged positions, where instead of slaving away somewhere in Naples and the back streets of Naples, we talk about these things in New York and Paris and London and so on. Yeah, so I'm not good at sketching what should be done. I'm really good at making ridiculous what has been done.
Io sono Donato Greco from the University of Naples. I'm a PhD candidate in international law. And I have a question for you about the Security Council and its role in managing with use of force. And I move from a statement of skepticism that Professor Conforti made in 2003, underlying the connection that binds the prohibition of the war of aggression on one side and the collective security system on the other side. Professor Conforti concluded that the prohibition works if the collective security system works. And since the latter hardly works, the former becomes ineffective. Do you agree with this perspective? And if yes, do you see any kind of solution?
Well, yes. So I think if the collective security system worked very well, then the world would not be the world as we know it. So the UN system, that's what. So this system, where there's a prohibition, a principal prohibition of the use of force and discretion with the Security Council, that presupposes that the great powers would be able to agree on many things, they would be ideologically in agreement, and that whatever it is that they agree would be largely agreed by you and me, and everybody else too. That's not at all the way the world is. And so I don't know which is worse. The situation where the great powers don't agree and the system is blocked, or the world where the great powers do agree. And all of us are, you know, under the soldier's foot of the great powers. So I'm a child of the Cold War. And in many ways, I can't believe I'm saying this, in many ways the Cold War was okay. And more okay than what came about thereafter. It's not that it was, in all of its aspects, in many other aspects it was really bad. But I'm afraid of the moment when China and Russia and the United States will agree on stuff and will impose that stuff on you and me. So I'm not looking forward to that. So Conforti, whom I know, is a really intelligent thinker of the law on the use of force and on collective security. And I read in his statement the view that the system for prevention of aggression doesn't work now because the collective security system doesn't work, and that it's unclear to us whether we want the collective security system to work in a very efficient way, unless, of course, human beings everywhere, from the White House to to here will become reasonable, right-thinking persons, which of course we think we are, and they're in the White House miraculously think they are. So as an international lawyer, one is always called upon to say how I would want the world to be, or what reform, what are the right reforms. So my life as an international lawyer has been an endless reform. Endless. So you in the UN and in international institutions, we do nothing else apart from reform them all the time. And by reforming, we keep them as they are, because reform was their point. They were meant to be reformed. We are good at reform. The next report, the report after the next, etc. We produce those reports. But nothing really significant is going to take place through those means, I don't think. And so when people ask me about how to make the world a better place, I suggest look elsewhere. Don't look at international institutions, international law, international lawyers. We do what we do. And if you need a lawyer's statement on something, ask a competent international lawyer to give you that statement. But they don't know how the world could be made a better place. That's a really, really difficult problem. So listen to Greta Thunberg. She has more wisdom in what she says than Conforti or I or any of us, because we are trapped in a vocabulary that contains the problems that it wants to resolve. You need another vocabulary. I don't have that.
Rolando. About Greta, we don't agree.
I will try to be as much as clear as I can, and forgive my English. It seems to me every time I heard speaking, first of all, I'm not a scholar in international law, so it's not my field. But every time I hear arguments and problems in this sphere, it comes to me the most significant problem is the problem of the authority, in the sense that in domestic domain we have sort of a clear authority which decide the case and discriminate and toward which we can raise our voice, for example. In international domain we seem to have a kind of state of nature in which every different subject basically in a different position have conflicts. And so it seems to me that particularly today we have two main perspectives. On the one hand, we have the idea to form a global united society in which we are not able to find a common authority. We have a macro subject like China, Russia, United States and so on, but we cannot really figure out how to have a united world. We could imagine this in the 90s where the US seems to be able to be the policeman of the world, so to speak. And on the other hand, we have this complexity of different subjects. What I'm going to ask is, should we try to imagine a world in which we have to regulate relation towards subject in a sense which we can speak about balance of power maybe, but in which so the objective would be to give to the different statual subject enough power to be a subject, because it seems to me that today we do have a subject who are able to impose their will and their authority also on their territory, and subjects which are not able to do that? Or should we aim to create a macro subjectivity, a macro policeman of the world who decide and regulate the relation between subjects? So empowerment or regulation? So this is.
Well, I'm really glad you asked that, and I don't know how much time we have, but I have lots to say to that, and fortunately this also allows me to rise from the hole that I've dug to myself in my answer to the previous question. So get back to a more professional way of speaking. So the question presupposes a binary understanding of the world, where on the one hand we have the international world or the international community that doesn't seem to have much authority, and then we have sovereign states. But that has no longer been, for a long time, that has not been an adequate understanding of how international law and a lot of international politics operates. Instead, a huge amount of authority, not all authority, but a huge amount of authority is being exercised by professional networks that are situated in between. Let me give you an example. So the most widely discussed phenomenon in the international legal world in the post-2000 era, apart from the war question, has been the fragmentation of international law. That is to say that the law is not a single thing out there, but we have a really powerful trade law with the trade law experts and trade law institutions. We have a really powerful system of environmental law with environmental institutions and environmental expertise. We have a really powerful system of humanitarian law with its institutions and experts. We have a powerful system of investment law with its experts and institutions. We have a powerful set of regional systems. So European Union and the law of the European Union would be an example, etc., etc. When a domestic government meets, the various ministers, the finance minister, the environment minister, the interior, well, interior may be a special case, but most of the ministries, they are completely hooked in a network of international institutions that operate with them, and their understanding of how to deal with problems is completely mediated by international knowledge systems, or systems of knowledge that have nothing domestic about them. So if you are a person in the finance ministry, for instance, then it doesn't matter if you're, so in Italy, for instance, it doesn't matter if you're Italian. You could equally well be a Finnish person, an American person, etc. Your training, the tools you have, the vocabulary, the institutions to whom you speak are utterly international. My friend and colleague David Kennedy has been preaching now with some power for the past 15 years or so on the world as ruled by experts. And I'm more and more inclined to think that he is right. And so it's not that we have sovereign state. No state is sovereign. They're completely tied in a network of expert knowledges of governance. You don't need to be Foucault in order to get the point, but it helps. So, and the international world is completely divided. So the international world of Geneva is very different from the international world of New York. So I want to press upon this point. So I am a UN person. So that's where I've been spending my life. And I know that the context of New York, where the Security Council meets and where the political activities are situated, has a wholly different nature to it. Lives in a wholly different bubble than the Geneva people. The Geneva has the humanitarian organizations, the UN social and economic activities, and they are just utterly different worlds. The people think differently, their projects are completely contradictory, etc. And environment and trade. So we know already, and especially in law schools where people make PhDs on typically topics such as trade and environment, trade and human rights and security, etc. We have already internalized that those are the solid anchoring points of the international world. Not the states, not Ukraine, Finland, Italy, but trade, environment, investment, intellectual property, human rights. They are all, and of course, they struggle against each other. They are sociologically completely different. Take a group of trade lawyers and take a group of environmental lawyers. You will immediately know which group is which, from the way they dress, from the way they speak, from the way they make friendships, from everything about them. And, you know, but inside these groups, the trade lawyers come from Italy, Finland, France, UK, everywhere. But what unites them is that they are trade people. And what unites the environmentalists is that they are environment people. So it's not as if international law would have stood still while the world was going in some direction. So the book that I published, which I mentioned, which has this Italian translation, has the subtitle, The Rise and Fall of International Law. Fall. So it's not fall for nothing. I mean that this thing with the idea of League of Nations and collective security and Security Council, you know, it's kind of zombie. It has no life to it. It still walks about there, but it's no life. Where life is in international law is in these special regimes. And of course, they are not united by a single authority. They fight against each other. Trade or environment, human rights or security, or investment. So they fight against each other, and it's interesting and important to participate in those fights. And in those fights, again, we see law as an ideology, or a set of ideologies. Law as a set of projects. Law as a project of making investment flourish. Or law as a project of making developing countries flourish. Or law as a project of making the environment flourish. And they contradict each other, these projects. And as I said, I'm really glad that I was able to come from the hole into which I've dug myself with Greta Thunberg and so on. So there is life in international law, and it's meaningful to participate in these projects and to try to win. And that's where things develop. But they are not coordinated. It's not, so we don't know how this is going to go. We know, of course, that some actors are more powerful than other actors. I often get PhD students who come to me thinking that I want them to write human rights theses. Well, yeah, so the first conversation we have with this person is, why on earth do you, so you are a person whom I like. Your political intuitions are mine. But why would you want to marginalize yourself by thinking of yourself as a human rights lawyer? Why don't you think yourself as a corporate lawyer? And try to have your career as the legal counsel to Exxon, for instance. And that's where you can have influence. That's where you're needed. You're not needed in some human rights reading group in some university's obscure corner. And whenever I tell these people this, I see all of a sudden their eyes and the sadness and no, that I wanted to become a human rights person in order to avoid sitting in those kinds of meetings, dressing in that way, thinking those thoughts. Well, that's a measure of the strength of your commitment. Whoever said to you that making the world a just place was a nice life? Of course it isn't. And if you think, anyway, so what my mission in life now is to try to convey to people who think about the world like I do, because I'm a political person. For me, law is a political tool. For me, for people who think like me, to try to find the places where they can make a difference, and to try to make them avoid the mistakes that previous people have made by marginalizing themselves, by thinking that by being a secretary of a Greenpeace association somewhere, that is important. I mean, that may or may not be important, but you have to think about that. You can't just take it for granted. Why did I go there? But is this being filmed?
Yes, but if law is an ideology, it will be used by discretion, by power. And in another sense, law is ideology as a self-representation of lawyers. I mean, ideology maybe fails consciousness too.
Yeah. So, well, now we enter the muddied waters of jurisprudence. And I was never really attracted to jurisprudence. I think in some ways jurisprudence is a mistake. And why do I think that? Well, I think that because, I'm coming to what you said, I think that because the jurisprudence classes at law schools are often the ones that are intellectually really demanding. And the jurisprudence people are often people whose political intuitions are where my political intuitions are as well. But when I see my potential allies, again, marginalize themselves by drifting into the furthest corner of the law school, where they are bound to have no influence to anything that goes on in the world, I am disappointed. So I think there's a lot of exciting and intellectually interesting thinking going on in contracts, going on in administrative law, going on in corporate law, going on in international law. I want this thinking to, the people who are interested in thinking about thinking, to go into those fields and do the thinking better in those fields instead of going to jurisprudence. So that's just a first footnote. So now I'm in the muddled waters of jurisprudence. Nevertheless, I have to be, because I have to explain, of course, that for me law is not something out there. For me law is what lawyers do and think. And we do and think different things. And so it's a phenomenological thingy. And that's how I've encountered it. I've never seen it hidden anywhere beneath the table, outside the door. It's always come to me by some lawyer in some case, or representing some country, or representing some organization, or trying to make a point. So law is a system of persuasion. We try to persuade each other by these performances that we think of as legal performances. They might be thought of as other kinds of performances as well. You have to be a really good performer in order to be a good lawyer. You can't be a good lawyer. But this is not something jurisprudence appreciates. And therefore I don't appreciate jurisprudence, because for me, as a political person, as a former diplomat, as a professor, persuading is really important. And persuading is where it's somehow at. So to say that law is ideological in some, I used the word an ontological center. So I don't believe in ontological centers. So to believe that law is out there, that it has an ontological center, then you can ask the question, well, whether that ontological center is ideological or not. And I think there is so that's a language game of a particular kind. But that doesn't speak to me. And I don't want to, so of course, I make points sometimes in a funny and slightly provocative way. And the point is not to disparage or attack anybody's interests in jurisprudence or criminal or law or being a Greenpeace activist. I mean, those are fine things to be. What I am disappointed of, and what I see as my task in life is to make people think more clearly about the choices that we have and about the false consciousness that we have. And sometimes that false consciousness involves belief in ontological centers. Now, sometimes thinking in terms of ontological centers gets you somewhere. And it gives you a voice that may seem persuasive in a jurisprudence crowd. And maybe the jurisprudence crowd should be convinced by something. But that's not my project. And I think thinking hard and clearly about things involves at least a part of thinking of law as a project and ourselves as participants in projects. And in a very classical Enlightenment sense, to be clear about what those projects are. Because we may participate in projects that are destructive without knowing it, because we have such a big interest in not knowing. And therefore, it is one's daughter or Greta Thunberg who needs to come in and say, why do you destroy the world pretending that you want to save it? And Dad, can you really look in the mirror after all this flying you have done all these decades? And you can say that international law is a good force for the good in the world. That it's a force which makes a lot of people like me to fly in a lot of places. Now, of course, again, this is a provocative point, but it's not a meaningless point. And it's a point that international lawyers don't think enough of. And it's only if we think enough of those and agonize over them with our daughters that, well, we may decide that, well, maybe a video conference could be a better thing. And why aren't they being used more and more? And I realize I'm speaking to people who've just invited me here, and I'm really grateful they have. But I cannot not think about this if I am in the business of enlightenment, if I am in the business of getting rid of false consciousness.
Thank you, Professor Koskenniemi. Thank you for your brute realism. I think we need it. I apologize for my rusty English, but my English is better than my Finnish. I think that you are maybe the only international public, general or public international lawyer that speaks without fears, with no fears of war. That uses the term war. International literature today commonly use other terms, military operations, humanitarian intervention, international police actions, and going on. Okay. I think, that's my idea, that the reason is that you are an historian too of international law. There was a time when, I think, to the classic textbook from Wheaton to Lauterpacht, from George Sell to Oppenheim, every international textbook opened with a sketch and a history of international law. Today, I think international lawyers often forgive that history, and maybe the lack of the term war is linked to this amnesia. It's my idea. So, war. I read, not at all, the so-called Tallinn Manual about cyber war. No? I'm interested in your opinion about that manual. Is it a manual? Is it a cyber war? Thank you.
Okay, so one of the hip themes in international law now is this cyber thing. And there's a lot of conferences in Europe, especially in the US too, on cyber war, on cyber security, on resilience. it's interesting to see once again a special field of law emerging from the law in general, in which particular people become authoritative, and in which particular ways of speaking become authoritative. And again, the Tallinn Manual, which is a manual produced under the auspices of the US Naval War Academy, especially by this really authoritative person, Michael Schmidt, an American professor really geared towards humanitarian law and so on, have monopolized ICT uses, that is to say, information and communication technology uses, in such a way that they themselves became authoritative in those uses and suggest to us that those uses should be addressed by a military language. I'm against that project. And I've spoken against cyber law and the Tallinn Manual, not because I don't think that internet operations, or ICT operations, as I would want to call them, operations conducted on the internet and information and communication technologies are not important. They are important, but because the problem has been monopolized by people whose intuitive reaction is, we shall use force, and who frame the problems in terms of the threshold for the use of force. Is this a cyber attack, a military attack in which we can respond by military force? I see that that's a completely American project. I'm not anti-American, damn it. I go to New York to teach next week. And my best friends are there, and other cliches. But the cyber war and the Tallinn Manual have framed and produced to us an understanding of information and communication technology that is tainted with this idea that military people should be the authorities and that security experts are the best experts here. That, I think, is really, really dangerous. Now, I've noticed that many other people think that as well. And the Tallinn Manual, which is still the only kind of private codification of the field, is still the only private codification of that field, that its status, it was, I think, the second edition was produced 2017, first one maybe 2015. I think its status has been going down. So I see more and more people operating in the cyber world who think, well, it's really useless. And what do we get? So Finland is never going to attack anybody because of whatever happens in Finnish ICT operations. And so lawyers from the third world are really, really antagonized by the Tallinn Manual because they see that the only thing that the Tallinn Manual is obsessed by is when does a cyber operation by somebody become so important that you can strike militarily at some public or private actor out there. If you are Senegal, you couldn't care less. But if you are Senegal, you are really interested in getting that that infrastructure and that technology and those funds that enable you to, have good ICT networks at universities and in public administration and in hospitals. And there I want to go. But the Tallinn Manual has nothing to say about any of that.
So, other question? No? Fiorinda lì.
Just to say thank you very much. It was not just very interesting, but it was also a little bit of fresh air, if I may say. Because I think your speech is not cannot really be loved by philosophers. because you know philosophers try to have strong ideas to deal with. You strong ideas, strong position, strong perspectives. You gave us a much weaker point of view, in a way, but I'm sure that you understand in which way I'm talking about weaker. But you bring you brought us in the middle of things. How complex, how difficult, how contradictory things are, and you gave us the feeling of a possible pragmatic approach, which is not living theory and which is use all what we have studied, all what we try to understand, and put all this in a way that we can use it. Maybe we can do little, we can do just a little thing, but there is something we can do. And so, for this reason, I really thank you, and I invite you with Nello Preterossi for a longer week next week.
Yes. Well, thank you so much for this lovely invitation, and as I said, I'm really embarrassed and that I'm here only for these 2 days and destroy the atmosphere in this way. And next time, I don't know, maybe I'll sail to Naples, but I certainly want to stay here for a longer time. It's the first time.
2 days. So, next time, many days.
Okay, let's do that.
Thank you so much.
Thank you.